Hey everybody, it's Brian with KC Legal Hackers. This is going to be our overview of intellectual property for independent creators here at the 2018 Open Media Legal Hack. And with me I have Danielle Merrick, who is the head of the Intellectual Property Clinic and the Entrepreneurial Legal Services Clinic at the University of Missouri-Kansas City School of Law, and she is going to provide us with an overview of some of the basic issues associated with copyright and trademark.
Hi there. So with copyright, we have a few things that we usually have to consider. And the two things that we're usually considering is how do we protect the work that we've created and how do we make sure that we're not infringing on other people's work. So copyright is anything that has a modicum of creativity. The second that you fix it in a tangible medium, you have a copyright in it. So what that means is if I have a piece of paper and I scribble a creative drawing on it, the second that I scribble that creative drawing on it, I actually already have a copyright in it. I don't have to register it with anybody. I don't have to do anything with it. I just automatically have a copyright in it. So getting a copyright doesn't require a lot of effort on a creator's part. They simply get it by creating it. Now, you can register that copyright, and when you register that copyright, that gets you some additional protections. So when we register a copyright, we can register it through the Copyright Office, which is maintained by the US government. And the Copyright Office has a website. You register all of the copyrights online at that website. The Copyright Office does not make any determination on whether or not something is creative or if it rises to the level of requiring copyright. They basically just look at, does it have any modicum of creativity? Is it fixed in a tangible medium? Yes, it is. All right, we give you a copyright. The only exception to that would be if they had some reason to know that whatever you're trying to register is not yours. So for example, if I drew a picture of Mickey Mouse and I tried to claim that I had a copyright in Mickey Mouse, they would say, no, Disney owns that, and so you can't register that copyright. To register a copyright in the United States is roughly $35. And so when you fill out this form, the only thing that you have to do is indicate what type of medium it's in. So if it's film or if it's in a paper, or it's a photographer, or it's a photograph, it's a manuscript, whatever it is. And then you have to upload a sample of that particular thing in order to register the copyright. So if it's a photograph, you have to upload a sample of the JPEG. If it's a musical recording, you have to upload a sample of the recording, etc. When you register a copyright, you get some additional statutory protections. Those protections essentially are you get the right to statutory damages that are above and beyond the regular damages. They're essentially punitive damages. Those are at $100,000 per instance of infringement. And then you also get some additional protections in terms of it puts everyone on notice that you own that copyright. But there is no requirement to register your copyright. You still have rights regardless if you register it or not. Now, on the flip side of copyright is how to make sure you're not infringing on someone else's work. So where I most commonly see this is if someone is going to take something that someone else made and they're going to incorporate a piece of that into a work that they're making. So let's pretend that I'm working with a graphic designer. The graphic designer might find an image online somewhere that they want to incorporate into a logo. That image was probably created by someone else, and if it's not an open source image, then that image, if they use it in this new design, will be violating someone else's copyright. So as creators, you have to both protect your own work and you have to make sure you're not infringing on anyone else's work with copyright. If we move to trademark, which is a slightly different topic, trademark is essentially protecting words and or logos or images. There are two flavors of trademark. There's what we call a service mark, which is normally a logo, and then there's a word mark, which is we're going to protect a specific word or series of words. Those are most often used by businesses, bands, things like that, some kind of formal business entity. They're not usually done by an individual, but they're usually done by an entity. A trademark, if we're looking at a service mark, so a logo, we register that with the trademark office. The trademark office also has a website, and when you go to that website, they have the ability for you to register trademarks online as well. Registering a trademark online, you don't have to have an attorney to do it. You are allowed to do it by yourself. They charge you roughly $295 per class to register a trademark. So what does registering a trademark entail? The first thing with the trademark is that you have to have something that is unique, fanciful. It can't be merely descriptive. So if I were opening a cookie shop, for example, I couldn't necessarily create the name of the cookie shop to be Danny's Cookie Shop and then try to register those words for any sort of protection. Those don't have anything that's fanciful about it. They don't have anything that's unique about it. It's just merely describing the product that I'm going to serve at the cookie shop. So alternatively, if we think of something like Kleenex, which is a brand name of facial tissue, Kleenex is something that has some level of uniqueness, and so the trademark office would say, okay, this is not merely descriptive, this is unique, this is fanciful, so now it's potentially eligible for trademark registration. The second thing that you have to look for is whether or not anyone else has that same trademark in the same class. So what classes are basically a designation of a product line or a service line. So for example, clothing is a class, airplanes are a class, plumbing fixtures are a class. So you can have someone who has a trademark in both, the same trademark in two separate classes. So the example I always use is Delta. There's Delta Airlines and Delta Faucets. They both have a trademark in the word Delta, but they're in two different classes, so it's okay. So if you, as a creator, were looking to file a trademark, you have to do a trademark search where you go on to the US Patent and Trademark Office's website and actually search the words or the images of the thing that you're trying to register and see if anyone else has a trademark in that same class. So let's pretend you were going to register something like Kleenex. You can't register that because Kleenex has it in like all areas. They've registered in all classes. But if you looked and Kleenex was only registered in facial tissues, but it wasn't registered in cars, for example, you might be able to get a trademark in the class of cars for the word Kleenex. So you're always looking to see, is this already registered? And if it is, what class is it in? If it's a class that's really far away from yours, you're probably okay. If it's a class that's near yours, you might be a little bit more concerned. So like if you were looking and they had it registered in t-shirts, but you want to put it on hats, those are both clothing. So the trademark office might argue that they're not going to allow you to have the trademark because there would be the problem of confusion. To register a trademark, once you've jumped those two hurdles, you've figured out that you have something that is not merely descriptive and you figure out that nobody else has it, then you can actually fill out the trademark application. The trademark application essentially makes you dictate who owns the trademark, what the trademark entails. If there's a logo, you have to upload the image so that the image is on file. And you sign all of this under penalty of perjury and you pay your fee. Now the trademark office operates differently than the copyright office in that they actually analyze a trademark. They look at it to determine, is it not merely descriptive? Is anybody else got the same trademark that would create confusion? And when we say confusion, what we're meaning there is that we don't want someone else to be able to open, let's see, like Kansas Fried Chicken instead of Kentucky Fried Chicken and operate under a trademark of KFC, because people who would go to Kansas Fried Chicken might think that they're getting, you know, Colonel Sanders 11 herbs and spices, but not actually getting that. And so that creates confusion, and the trademark office would say, no, we're not going to grant that trademark because we're creating confusion in the marketplace. The final thing about trademarks is that trademarks are required to be used in commerce. And so you can file for a trademark before you're using in commerce, but I generally advise that you not file for a trademark until you're actually using the mark in commerce. And what they mean by using it in commerce is that if it's a logo, it needs to be on something that you are actually selling in the marketplace and have completed a sale. If it's words, the same thing. It's got to be on something that's in the marketplace and you've actually completed a sale. With both copyright and trademark, you are required to what we call enforce your trademark or police your trademark and or copyright, which means that you have to affirmatively look out in the world, and if anybody else is using your mark, you have to come and tell them, please stop. The way that you tell them to stop is by issuing what's known as a cease and desist. You may at some point be on the receiving end of a cease and desist. I hope you aren't, but you might be. If you get that, it's a warning shot across the bow. It's basically whoever owns that saying, hey, stop using this, and if you don't, then I'm going to sue you. You have that same right if someone is infringing on your work to say, hey, stop using this, and if you don't, then I'm going to sue you. So if you get a cease and desist, you should probably stop using it. Consult with an attorney if you want to try and continue using it, because that does get into an involved litigation battle. But if you are creating content of any sort, you're going to run into copyright and trademark at some point in the creation of your content. So there are a lot of great videos on the Trademarks Office website about trademark basics and how to file trademarks. There are also videos on the copyright website as well. And I think we're going to put links to those up.
We'll be linking to those we'll be linking to those directly underneath these videos when we start posting them, so that it's very easy. Kind of this page can serve as a one-stop shop for what you're looking for and what you need in order to do the whole copyright and trademark process.
Yeah, and the copyright website also has a bunch of kind of like tutorials to walk you through the process as well. And there's, I think it's Cornell Law School has something that deals with an entire page dealing with fair use.
I think it's the Legal Information
I do believe that
Center
is,
or something.
I think it is.
But we'll link to there as well.
Yeah. So I recommend all of those sites, and that's a pretty brief overview. There's a whole lot more that we could talk about trademark and copyright, but this at least gives you a start.
Awesome. Thank you very much.
Yeah, thanks.